We've got to begin with the United States Supreme Court. They are hearing arguments today in the Birthright Citizenship case. And this case is not going the way some people wanted it to go. I have to pause here. And I've got to, I got to say something, and I mean it very respectfully, though I'm learning that it's not going to be taken very respectfully to some who hear this. Again, I don't mean disrespect here, but there is a class of person, they tend to be a little older, and they get very, very emotional about birthright citizenship, and they have done their own research. Some of them are lawyers, and they have done their own research. We have a couple who call the program very angrily every time the issue comes up and are very insistent they are right and everyone else is wrong. And again, it doesn't matter how I say it short of affirming them. They're going to be very hot-headed and angry about it if you disagree with them. They're very insistent, and emotion has trumped reason at this point. Let me just give you the breakdown here. Since the Wong Kim Ark decision in the 1890s, this country has interpreted the citizenship clause of the 14th Amendment to mean if you come into the country, you give birth in the country with limited exception, that child born here is an American citizen. There is language in the 14th Amendment that people have interpreted to preclude illegal immigrants. The original author of the 14th Amendment in the Senate suggested that transient people in this country it would not apply to. The language is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, what people who say the Section 1 of Article of the 14th Amendment don't apply to illegal aliens say is, well, illegal aliens are not subject to the jurisdiction of the United States. We have been getting this wrong since the 1890s. The Wong Kim Ark decision very specifically involved parents who were legal residents of the United States. They were essentially green card holders. They were allowed into the country. They were Chinese. They had been given permission to be in the country. Their child was born in this country. They eventually repatriated to China. Their child went back to China to visit them. At the time, there was growing animosity towards Chinese immigrants. When the child, Wong Kim Ark, came back, Customs Office said, you're not an American citizen. You can't come in. The Supreme Court said actually his parents, they were lawfully allowed to be here at the time. He, therefore, was born as an American citizen because they were subject to the jurisdiction thereof. And so the people who say we get it wrong say, well, the difference is Wong Kim Ark's parents were legally allowed to be in the United States. Now, if you read the Wong Kim Ark decision, they go through a history at the time of birthright citizenship. And one of the distinctions is if you are on a ship at sea in international water and you were born, your citizenship goes where your parents are, not to the country under whose flag you're sailing on. But also in the British Empire at the time, the system from which we are derived, if you are passing through a British imperial territory and you give birth, your child is a subject to the crown of Great Britain, even if you're Christians. And they pointed that out in the case, which is a lot of the reason why people have come to the conclusion that illegal aliens are subject. The other is the phrase subject to the jurisdiction thereof. And what does that mean? Let me give you this contrast. If you are a diplomat in this country from a foreign government, you are an ambassador, the child of an ambassador, the spouse of an ambassador, you have diplomatic immunity. If you are in if you go out and get drunk, and you're in a car crash and you kill someone, you cannot be charged with vehicular homicide. You are instead thrown out of the country because you are not subject to the jurisdiction of the United States. You have diplomatic immunity. Now, oftentimes what will happen in those cases is that the foreign country will say, we're surrendering that person's diplomatic immunity so they can have charges pressed. But that country has to decide. We don't get to decide. If you're an invading army in this country, you don't respect the jurisdiction of the United States. Now, contrast the person with diplomatic immunity to an illegal alien who gets drunk, gets behind the wheel, causes someone to die. that person goes to jail. Why? Because they are subject to the jurisdiction of the United States. We don't have to wait for the foreign country to surrender their immunity. We can prosecute them. And therefore, that is why most people who have studied the 14th Amendment say, yeah, the children born of illegal aliens, the illegal aliens actually are subject to the jurisdiction of the United States. If they break the law here, they get punished here, and like a diplomat. Now, the minority says, no, it's different. And I understand and respect their decision. I think they're wrong. I understand the argument. The problem is the people in the minority feel so put down on that they're convinced they're right and they're in the minority that they get very hostile to anyone who disagrees with them on the case, and they want you to know they've done their own research and they've studied it. That's fine. I respect that. And I understand you put 10 lawyers in a room, you're probably going to get 15 different opinions. But the majority consensus since Wong Kim Ark, largely because of the dicta, not the court ruling, dicta is opinion of the court that's not binding, highlights the fact that in the 1800s, if you transited through a country and gave birth in most of Europe, and particularly the British Empire, from which you're descended, your child becomes a subject of the crown of that country, and they viewed it the same way. Most interestingly today, however, the case before the United States Supreme Court about birthright citizenship is not really getting into any of that, and it's frustrating people who want it to be about birthright citizenship. What is actually coming before the court today is the universal injunction portion of the argument. The court is far more inclined to entertain the arguments on universal injunctions. Why? There have been 40 universal injunctions imposed on Donald Trump in his first 120-odd days of being president of the United States, more than any other president. Most of those 40 injunctions come from 5 judges. In other words, there's something called forum shopping, where you go find the forum, the court, most likely to be favorable to your arguments. You ensure there's a judge there who's going to hear your case, and well, you're probably going to be able to get a universal injunction that applies to everyone everywhere. The court has been frustrated. Both sides, interestingly enough, have been frustrated with the growing use of universal injunctions. You'll not be surprised to learn that today it is the progressives on the court who seem much more amenable to them than the conservatives, as opposed to when Biden was president. It was the liberals on the court complaining about the shadow docket. What is the shadow docket of the United States Supreme Court? That is when the court in the middle of the night makes decisions. There aren't arguments. There aren't hearings. It's not public. They're deciding things behind the scenes, often very rapidly. And the progressives on the court have complained about the shadow docket for years. Now suddenly they're quite fine with the shadow docket, because that's where a lot of these cases involving universal injunctions go. Justice Alito, speaking for many on the court and not just the conservatives on the court, has expressed frustration that district court judges are monarchs of their realm. Appellate court judges and the Supreme Court are not. They've got multiple parties on a court, but a district judge is all alone. And the district judge all alone gets to make decisions. He's the king of his realm. And if he decides that you get a universal injunction, you get a universal injunction. And most often, an appellate court does not question the district court's use of a universal injunction. It's got to make it to the Supreme Court. And then they use the shadow docket. And then when it's a progressive president, the progressives get mad. When it's a conservative president, the conservatives get mad with all the frustrations. And the courts have largely had enough. Sonia Sotomayor got so heated in the argument that John Roberts had to rein her in. She kept interrupting him. And he has now finally had to go to asking the justices if they have questions in the case, instead of just letting them interrupt each other, because Sonia Sotomayor wouldn't stop interrupting. Passions are very high on both issues, birthright citizenship and on universal injunctions. The Supreme Court seems very sympathetic to the idea that instead of using universal injunctions, use class action lawsuits. The Solicitor General is arguing to make class action lawsuits. They've been talking a lot in this case about something called a bill of peace. Now, I am not going to pretend to be an expert on bill of peace. I was a lawyer. I did do constitutional law, but I'll just give you the basics here. The conservatives say bill of peace is a very old English law thing that was transported into American common law, and the conservatives say it evolved into class action lawsuits. And in fact, there are Supreme Court precedents that refer to the bill of peace as the genesis of a class action lawsuit. The progressives on the court today, despite prior Supreme Court cases saying as much, are very insistent it was actually the predecessor to the universal injunction, and that although we've only been having universal injunction since the 1960s by that name, they actually go back to the beginning of the country. The conservatives are saying, no, actually what goes back to the beginning of the country was something akin to a class action lawsuit. A class action lawsuit is handled differently. It's more subject to appellate review earlier in the case without having to go to the Supreme Court, and universal injunctions largely have to make it all the way to the Supreme Court to get heard. Here's my guess. My guess is that those of you who want resolution on birthright citizenship and the Supreme Court today are going to be disappointed. In fact, there have been several questions from the justices about birthright citizenship, but most of the questions have been about universal injunction. And my suspicion is what's going to happen is that they're going to punt the case back to the district court for resolution after dealing with the universal injunction situation. And my guess for the progressives is you're not going to like the outcome of this. The reality is progressive judges are far more willing to issue universal injunctions than conservative judges. There are some conservative judges that will issue universal injunctions, but they overwhelmingly tend to come from progressive judges. And as I said back in January, I said this when Donald Trump got inaugurated as president, that the progressives were going to overplay their hands in district courts. And I think that's what's about to happen, based on the arguments of even Amy Coney Barrett, Neil Gorsuch, Brett Kavanaugh, John Roberts, who, by the way, John Roberts has long been frustrated by the abuse of universal injunctions. I think you're going to see the Supreme Court rein in the use of universal injunctions, and we're not going to get resolution on the birthright citizenship portion of the case. We're going to get resolution on the universal injunction portion of the case, and we'll have to revisit the birthright citizenship matter later. It's been very interesting to hear the arguments at the U.S. Supreme Court today. You know, the news organizations tried to get them to put cameras in for this case, claiming it was historic. The court declined. They're not going to put cameras in. We were able to hear their voices, though, and there does seem to be broad consensus, even among the liberals in the court, that there's a problem with universal injunctions, but the progressives on the court seem to be far less willing to change this, largely because right now it's benefiting progressives to put a hold on Donald Trump. I think, though, the conservatives are about to tell progressives you've overplayed your hand. You know, I've been warning, again, since January, I've been warning progressives you were about to have the Supreme Court kill off universal injunctions or at least severely restrict them. And that, I believe, is actually what's going to happen based on the way the oral arguments are shaping up today.